Now it's time to cover third part of polity, which cover the states. Okay, so very first, the governor is there. The Constitution of India, Article 153 to 167 in Part 6th of the Constitution deal with the state executive. So be careful, Part 6th and Article 153 to 167. The state executive will consist of the governor, the chief minister, the council of ministers, and the advocate general of the state. The governor is the chief executive head of the states, but like the president, he is a nominal executive head. Okay. Normally or usually there is a governor for each state, but the 7th Constitution Amendment Act of 1956 facilitated the appointment of the same person as a governor of for two or more states. He is appointed by president on the recommendations of a Union Council of Ministers. Qualification: citizen of India, completed 35 years of age, shouldn't be member of either House of Parliament or the state legislature, must possess the qualification for membership of a state legislature, must not hold any profit of office. His usual term of office is 5 years, but he holds office during the pleasure of president. Can give his resignation or can be removed earlier by president. His oath is administered by the Chief Justice of the concerned state High Court. Powers: executive powers, legislative powers. In legislative powers, you can have address the first session of the state legislature, appoints 1/6 member of legislative council, nominates one member from the Anglo-Indian community in the legislative assembly, can promulgate ordinance when the state legislature is not in session. These ordinances must be approved by the state legislature within 6 weeks. Regarding assent of bill, he can give his assent to the bill. He can return it if it is not a money bill, or reconsideration, suggesting alternations. But such bills, when passed again, have to be given assent. And third one, you can say he may reserve the bill for the consideration of president. Financial powers ensures the budget is laid. All money bills can be introduced on his recommendations only. Then he can make advances out of the contingency fund of the state. He constitutes a finance commission for every 5 years to review the financial position of the panchayats and municipalities. Then judicial power: he can grant pardon, reprieve, respites, and remission of punishment, or suspend, remit, or commute the sentence of any person. Emergency power: he recommends the president rule, Article 3556. When the president's rule is in the progress, he becomes the agent of the union government of the state. That time he takes over the that time he takes over the reign of administration directly into his own hand and run the state with the aid of civil servants. He act as the chancellor of state universities and appoint vice chancellors. After the 42nd constitutional amendment, ministerial advice has been made binding on the president, but no such provisions has been made with respect to the governor. Sarkaria Commission suggested that chief minister should be consulted while appointing the governor. Only unquestionable person be there. Active politician should not be appointed. Removal should be difficult. No need to remove the post of governor. When we talk about chief minister, he is real executive head of the state, appointed by governor. Governor administered his oath and his council of ministers. If CM resigns, entire ministry resigns. Now it's time to understand state legislature. Article 168 to 212 in Part 6 of the Constitution deal with various provisions of a state legislature, unicameral or bicameral. Unicameral means one house is there, and bicameral means two houses. Bicameral states are 7 states like Bihar, Jammu Kashmir, then Karnataka, Maharashtra, UP, Andhra Pradesh, and Telangana. Legislative Council can be created or abolished by the Parliament on the recommendation of Legislative Assembly. Legislative Council, or you can say Vidhan Parishad, also known as Upper House, like Rajya Sabha, it is also permanent house and can't be dissolved. Strength: the total strength cannot exceed 1/3 of the strength of Legislative Assembly, subject to a minimum of 40 members. As per Article 169, if the Legislative Assembly passes a resolution for abolishing or creating of the Legislative Council by a majority of the total membership of Assembly and by a majority of not less than two-thirds of the members present and voting, the Parliament may approve the resolution by a simple majority. The resolution passed by the Legislative Assembly for the creation or abolition of the Council is not binding on the Parliament. The tenure of a Vidhan Parishad is 6 years term with one-third members retiring every 2 years. Okay, the qualification is same as Lok Sabha except the age of which is 30 years. Election, indirect election is there. One-third of the members are elected by the local bodies in the state, like municipalities, panchayats, etc. One-third by legislative assembly. One-twelfth or by university graduates of at least 3 years standing and residing within the state. One-twelfth of by teacher, not less than secondary school or 10th standard of at least 3 years standing, and one-sixth nominated by the governor from among those persons who distinguished themselves in literature, science, art, cooperative movement, and social service. Thus, six out of fifth, sixth of the total members of legislative councils are indirectly elected, and one-sixth are nominated by governor. The members are elected in accordance with the system of proportional representation by means of a single transferable vote. The chairman, the council elects a chairman and a deputy chairman from amongst its members. Number of seats in LA or LC. So very important, in Uttar Pradesh, Legislative Assembly has 403 seats and Legislative Council has 100 seats. Now it's time to understand Legislative Assembly. Vidhan Sabha, also known as lower house, just like Lok Sabha, consists of directly elected representatives, has a term of 5 years. The Council of Ministers is collectively responsible to the Assembly. Strength not more than 500 and not less than 60 members. The governor can nominate one member from the Anglo-Indian community. Qualification council except that the minimum age is 25 years. And speaker or deputy speaker is there. Every legislative assembly chooses its two members as speaker and deputy speaker. Powers can legislate on subjects contained in the state list as well as in concurrent lists. Participates in the election of president. Has a share in the amendment of constitution, as some provisions can be amended after ratification by the legislature on of half of the states. Money bills only introduced in legislative assembly. Then at most the council can detain or delay the bill for a period of 4 months. There is no provision of joint sitting. Thus the council has been given much lesser significance, position and authority that of Rajya Sabha. Assent of governor, he may give his assent to the bill, he may withhold his assent to the bill, or return the bill for reconsideration, and he may reserve the bill for the consideration of president, article 200. So it gives the power if a governor saves or reserve the bill for consideration of president, that is given in article 200. Now it's time to understand High Court. The institution of High Court originated in India in 1862 when the High Courts were set up at Calcutta, Bombay and Madras. In 1866, a fourth High Court was established at Allahabad. The Constitution of India provides for a High Court for each state, but the 7th Amendment Act of 1956 authorizes the Parliament to establish common High Court for two or more states. Article 214 to 231 in Part 6 of the Constitution deal with the various provisions of High Courts. Presently, there are 25 High Courts in India. Delhi is the only UT that has a High Court of its own. Consists of Chief Justice and other such judges are appointed by President. The Constitution, unlike in the case of Supreme Court, does not fix any minimum number of judges for a High Court. A judge of High Court can be transferred to another High Court without his consent by the President. Appointment of judges, you can say Honorable Supreme Court of India on October 16th, 2015, quashed the National Judicial Appointment Commission, that you can call it as NJAC Act, and declared the 99th Amendment to replace the collegium system of appointment of judges to the High Court as unconstitutional. What are the main qualification? You can say he can must be citizen of India, advocate of High Court or two such courts in succession for at least 10 years, or such should have judicial office in India for a period of at least 10 years. The constitution has not prescribed the minimum age for appointment as a judge of High Court. Oath or tenure, you can say an oath or affirmation before the governor. Then the constitution has not fixed the tenure of judges of High Court. He holds office until his age is 62 years. He can resign from the office from his by the president. Then jurisdiction and seats of high courts, you can say Allahabad in 1866, Uttar Pradesh, its seat is there, Allahabad, and bench is there at Lucknow. Bombay, you can say have Maharashtra, Dadar Nagar Haveli, Goa, Daman and Diu. Then its seat is Mumbai, and it was established in 1862. In the same year, Calcutta also established. In Calcutta, you have 1862, West Bengal and Andaman Nicobar. Kolkata has a circuit branch in Port Blair. Then Guwahati in established in 1948. Assam, Nagaland, Mizoram, and Arunachal Pradesh. All these four states have their high court there. Guwahati bench at Kohima, and circuit benches and at the Imphal, Agartala, and Shillong. Removal, you can say the president can remove a judge of high court only if the parliament passes the resolution by a majority of total membership of each house and a majority of not less than two-thirds of its members present and voting in each house. In short, you can say a removal motion signed by 100 members in the case of Lok Sabha and 50 members in the case of Rajya Sabha is to be given speaker and chairman. It is interesting to know that no judge of High Court has been impeached so far. Like Supreme Court, High Courts are also have the power of judicial review. Subordinate courts are there, district judges and session judges. So here is someone very interesting qualification. Sorry, classification is there. High Court. Then in after High Court, district and session judges, High Court is there. Then judge. This court is divided in two parts: civil side and criminal side. In civil side, we have subordinate judge court, and then after municipal court, and in criminal side we have chief judicial magistrate court, and then after judicial magistrates court. Now it's time to understand union territories. Union territories, under Article 1 of our Constitution, the territory of India comprises three categories of territories: territories of a state, union territories, and territories that may be acquired by the government of India at any time. UTs are under the direct control and administration of the central government. Hence, they are also known as centrally administered territories. There are 8 territories now: Andaman Nicobar, Delhi, Lakshadweep, Daman and Diu with Dadar Nagar Haveli. Okay, then Puducherry, Chandigarh, and Ladakh. Till 1973, Lakshadweep was also known by Lakshadweep, Minicoy, and Amedini Dev Island. Article 239 to 241 in Part 8 of the Constitution deal with the Union territories. So be careful. Part 8 of the Part 8 and Article 239 to 241 deals with UTs. Every UTs is administered by President acting through a administrator appointed by him. It may be the president can specify the designation of an administrator. It may be a lieutenant governor or chief administrator or administrator. At present, it is lieutenant governor in the case of Delhi, Puducherry, and Andaman Nicobar, and administrator in the case of Chandigarh, Dadar Nagar Haveli, Daman Diu, and Lakshadweep. The union territories of Puducherry and Delhi Puducherry in 1963 and Delhi in 1992 are provided with the Legislative Assembly and a Council of Ministers headed by Chief Minister. At present, it is a Lieutenant Governor in case of Delhi, Puducherry, and Andaman Nicobar Island, and administrator. The UTs of Puducherry and Delhi are provided as Legislative Assembly and Legislative Councils of Ministers. Delhi is the only union territory. It has high courts of its own. Now it's time to understand federal system. The framers adopted the federal system due to two main reasons: the large size of country and its socio-cultural diversities. The term federation has nowhere mentioned in the constitution. Article 1 of the constitution describes India as a union of states. According to B.R. Ambedkar, the phrase union of states has been preferred to federation of states to indicate two things. The Indian federation is not the result of an agreement among the states like an American federation, and the states have no right to cede from the federation. The federation is union because of the indestructible federation features of the constitution. So here I'm going to tell you features of a federal system, that is dual polity, union at the center and states at the periphery. Then you written constitution, the lengthiest constitution of the world we have, which has 465 articles and 12 schedules. 25 parts are there. A division of powers, union list, state list, and concurrent list in the seventh schedule. That is so shares division of powers. Then supremacy of the constitution, judicial review is given. Then rigidity of constitution, the constitution is rigid to extent that those provisions that which are concerned with the federal structure, central and state relations, and judicial organizations can be amended only by the joint action of the central and state governments. Independent judiciary, so as we know that, and bicameralism, it means Rajya Sabha and Lok Sabha. Unitary features of the constitution, we have a strong center. Okay, union list consists of more subject than state list. Then residuary powers have been also left with the center. Then states not indestructible. Unlike the other federation, the states in the India have no right to territory integrity. The parliament can be unilateral action, change the area boundaries or the name of any state. Then single constitution is also a feature of unitary feature. Then flexibility of the constitution, no equality of state representations. Then it has emergency provisions in national, state, and financial emergencies. Then single citizenship is there, integrated judiciary, Supreme Court at the top and state high courts below it. Then all India services like IAS, IPS, and IFS, which are common of to both the center and the state. Integrated audit machinery, parliament's authority over state list, and appointment of governor, integrated election machinery, and veto over state bills. So these are the features of unitary features of our parliament. Now I'm going to tell you something about Sarkaria Commission. After demands of greater autonomy to states, appointed in June 1983 under Justice R.S. Sarkaria, a retired judge of Supreme Court, other members were B. Sivaraman and Dr. S.R. Sen. The commission had submitted its report in January 1988, recommended a process of consultation by center on all concurrent subjects, import after commendation being enter recommendation mean. Then what are the main recommendations? A formation of inter-government council consisting of prime minister and chief ministers. Then sparing use of article 356 regarding president's rule. Then regarding governor, previously discussed already, the judges of high court shouldn't be transferred without their consent. Three language formula should be implemented. Central control over the radio and TV should be relaxed. Favored sharing of cooperation tax and between the center and states. Strongly favored interstate council as maintained in article 263. Its name should be changed to intergovernment council. And then favored retention to National Development Council and suggested activation of zonal councils. Here I am going to discuss something about union-state relations. The Constitution of India, being federal in structure, divides all powers, legislative, executive, and financial, between the center and state. The center-state relations can be studied under three heads: legislative relations, and administrative relations, and financial relations. So when we talk about legislative relations, the constitution divides the subjects into three lists: union list, state list, and concurrent list. Union has 100 subjects, state list has 61 subjects, and concurrent list has 52 subjects. So parliament has exclusive power on union list, contains subjects like defense, foreign affairs, currency, communication, citizenship, interstate trade and commerce, banking, atomic energy, post and telegraphs, and etc. The state list consists a subject on which ordinarily the states alone can make laws. These includes public order, police, administration of justice, prison, local government, agriculture, public health and sanitation, irrigation, and etc. When a proclamation of emergency is in operation, Parliament can legislate on matters enumerated in all the three lists. Both Parliament and state legislature can legislate on the subject contained in the concurrent list. Contains subjects like criminal and civil law, forest, education, marriage, divorce, drug, trade union, labor, welfare, newspapers, book, printing press, population control, and family planning, and etc. Residual powers, example of subjects not included in any of the list rest with the union government. Article 200 directs the governor to reserve a bill passed by the state legislature for the consideration of its president if it is in the opinion it passed into law would derogate the powers of high court. Administrative relationship, when we talk about the Indian institution, sorry, constitution has a strong bias towards the center, make it a strong the central administration prevails with the state administration. If the state does not comply with the directives of the center, the latter may invoke Article 356 and take over the administration of the state of itself. Financial relationship, when we talk about states are generally greatly dependent on the center. Constitution provides inadequate sources of revenue to the states. Therefore, they have to depend on the center for subsidies and contributions. Unions exercises control through Controller General of India CAG, who audits the state accounts, and appointment of finance commission by president every 5 years also adds to it. When we talk about the scheme of distribution of revenue, Article 268 provides the scheme of distribution of revenue between the union and the states. The parliament has exclusive power to levy taxes on subjects enumerated in the union list, which are 15 in number. The state legislature has exclusive power to levy taxes on subjects enumerated in the state list, which are 20 in number. Both the parliament and the state legislature can levy taxes on subjects enumerated in the concurrent list. The residuary power of taxation, that is the power of to impose taxes on not enumerated in any of the three lists, is vested with the parliament. Under this provision, the parliament has imposed gift tax, wealth tax now abolished, and expenditure tax. Distribution of non-tax revenues. The center the receipts from the following from the major sources of non-tax revenues and centers: posts and telegraphs, railways, banking and broadcasting, coinage and currency, and central public sectors enterprises. The states the receipts from the following from the major sources of the non-tax revenues are irrigation, forests, fisheries, and state public sector enterprises. Apart from these, the center also has powers to grant loans and provide grant in aid in Article 275 to the states, especially for the purpose for promoting the welfare and scheduled tribes and cities. Interstate water disputes or interstate relations. Article 262 of the Constitution provides the education of interstate water disputes. So, for the central government has set up 8 interstate water disputes tribunals: Krishna Water Dispute Tribunal in 1969, Maharashtra, Karnataka, and Andhra Pradesh; Godavari Water Dispute Tribunal in 1960s, Maharashtra, Karnataka, Andhra Pradesh, Madhya Pradesh, and Orissa; Narmada Water Disputes Tribunal in 1969, Rajasthan, Gujarat, Madhya Pradesh, and Maharashtra. These are the important one. And many more are there. Okay, now let's turn to understand interstate council. Article 263 contemplates the establishment of interstate councils to effect coordination between the states and between the center and states. Thus, the president can establish such a council if at any time it appears to him that the public interest would be served by its establishment. The Sarkari Commission on the Central State Relations made a strong case for the establishment of a permanent interstate councils under Article 263 of the Constitution. In pursuance of the above recommendation of Sarkari Commission, the Janata Dal government headed by VP Singh established the Interstate Council in 1990. It consists of the following members: Prime Minister as a chairman, Chief Ministers of all states, Chief Minister and union territories having legislative assemblies. The fourth one is administrators of UTs not having legislative assemblies, governors of a state under president's rule, and sixth central cabinet ministers, including the home minister, to be nominated by the prime minister. Five ministers of cabinet rank ministers of state. These are the members of interstate council. Now it's turn to understand zonal council set up under State Recognitions Reorganization Act 1956. They are statutory and not the constitutional bodies. Northern zone, central zone, eastern zone, western zone, and southern zone and northeastern zone. Six zones are there. Northern zone consists of Punjab, Rajasthan, Haryana, JNK, and Himachal Pradesh, Chandigarh, and National Capital Territory of Delhi. So Delhi is in northern zone. Now, when we talk about central zone, it covered UP, Chhattisgarh, Uttarakhand, and MP. And then eastern zone, Bihar, Jharkhand, West Bengal, and Odisha. Western zone, Maharashtra, Goa, Gujarat, and UTs of Dadar Nagar Haveli and Daman Diu. Then southern zone covers Maharashtra, Goa, Gujarat, and UTs of Dadar Nagar Haveli and Daman Diu. Now, northwestern eastern zone, it was created in 1972 for Assam, Manipur, Tripura, Meghalaya, Nagaland, Mizoram, and Arunachal Pradesh. When we talk about emergency provisions, the emergency provisions are contained in part 18th of the Constitution from Article 352 to 360. These provisions enable the central government to meet any abnormal situation effectively. Central government becomes all powerful and states go into a total control of center. An emergency due to war or external aggression or armed rebellion, Article 352, this is popularly known as national emergency. An emergency due to failure of constitutional machinery in the states, Article 356, this is popularly known as President's Rule. Okay, so 356 President's Rule. And financial emergency due to the threat of financial stability or credit of India, Article 360 is known as financial emergency. National emergency, it should be declared in the situation of war or external aggression. Okay, external emergency. Then on the other hand, when it declared on the ground of armed rebellion, it is known as internal emergency. Okay, 44th Amendment Act of 1978 substituted the word armed rebellion for internal disturbance. The president can proclaim a national emergency only after receiving a written recommendation from the cabinet. So it is really very important point. President can proclaim a national emergency only after receiving a written recommendation from the cabinet. The proclamation of emergency must be approved by the both of the houses of parliament within 1 month of the date of the issue. If approved by the houses, the emergency continues for 6 months and can be extended to an indefinite period, but with the approval of parliament every 6th month by a special majority. So every resolution approving the proclamation of emergency, whenever the emergency occur, then every proclamation must be approved by a special majority. Effect of national emergency: the life of Lok Sabha. The life of Lok Sabha may be extended beyond its normal term, 5 years, by a law of parliament for 1 year at a time. The sixth fundamental rights under Article 19 can be suspended only when the national emergency is declared. The president cannot suspend the right to move to court for the enforcement of fundamental rights guaranteed by Article 20 and 21. This type of emergency has been proclaimed 3 times: 1962, 1971, and 1975. President's rule, when we talk about Article 356, deals with this. President's rule continues for 6 months. It can be extended for a maximum period of 3 years. 59th Amendment Act 1987, with the approval of the parliament every 6 months. Since Article 356 has become one of the most controversial and most criticized provision of the Constitution, because since 1950 the President's rule has been imposed on more than 100 occasions. Financial emergency, when we talk about in Article 360, it is there, and a proclamation declared financial emergency must be approved by both of the houses of the Parliament within 2 months from the date of issue. One approved by both of the houses of Parliament, financial emergency continues indefinitely till it is revoked. And then a resolution approved the proclamation of financial emergency can be passed by either house of the parliament only by a simple majority. Effects of financial emergency, we can say reduction of salaries, allowances of all or any class of persons is serving in the states. Reduction of salary, the president may issue directions for the reduction of salaries and allowances all or any class of persons serving in the union and the supreme court and high court. Union Public Service Commission we are going to discuss. Article 315 to 323 in part 15, it is deals with the UPSC. Okay, article 315 to 323. Chairman and other members appointed by the president. No qualifications are prescribed for the commission. Okay, members, and office of a term of 6 years or until they attain the age of 65 years. Resignation they should give to president. Not eligible for the further employment. What are the main functions of UPSC members? To conduct exams for appointment of the services under union. Advise the president, not obligatory on its matters of promotion, appointments and transfers for the services. All disciplinary matter affecting a person in the services of union. Okay, now it's time to understand CAG. CAG is mentioned in 148 article. Okay, head of the Indian account audit and accounts department, appointment by done by the president. Hold office till 6 years or till 65 years of age. He can also be removed by president on same grounds and in the same manner as a judge of Supreme Court. He is not eligible for the further office, and that office are charged upon the consolidated fund of India. Okay, so whatever salaries and allowances he get, it is from consolidated funds of India. Thus they are not subject to the vote in the parliament. He is the guardian of the public purse. CAG act as a friend, philosopher and guide for Public Account Committee of the Parliament. Now turn to understand Attorney General. Attorney General is mentioned in Article 76, has provided for the office of Attorney General, highest law officer in the country. He is appointed by the President. He must be a person who is qualified to the appointment of the Judge of Supreme Court. The term of office of AG is not fixed by the Constitution. Further, the Constitution does not contain the procedure and grounds of his removal. He holds office during the pleasure of President. He is entitled to audience in all courts of the country and can take part in the proceedings of a parliament. He is also allowed to take up a private practice, provided the other party is not the state. Because of this, he is not paid salary but a retainer to be determined by the president, equivalent to the salary of a judge of Supreme Court. It is a political appointment, and therefore whenever there is a change in the party of in the power, the Attorney General resigns from his post to enable the new government to appoint its nominee. The Attorney General is assisted by the Solicitor General and additional Solicitor General. What are the functions? All such legal matters which may be referred or assigned to him by the president appears before the Supreme Court and High Court in cases involving Government of India. Solicitor General appointment done by for the 3 years. Okay, Article 76 does not mention about the Solicitor General and additional Solicitor General. Advocate General of the state, it is mentioned in 165, and it is the highest law officer in the state. Thus he corresponds to the Attorney General of India. He is appointed by the governor. He must be a person who is qualified to be appointed as a judge in the High Court.